is Honorable Sechku. I'm the one who picks who to speak. Yeah. So, Honorable Jonathan Odur, then Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the Judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he is trying to do is trying to delay substantive justice. The orders are as clear, and that court-martial, in my understanding, has not been disbanded. What had expected today or yesterday was for the court-martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared, we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As Parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here. Would you now? And Mr. Speaker, this letter from the President is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us clearly if this advice that he has told us here is exactly what he rendered to the head of the state? Because what the President wrote potentially undermines the rule of law, undermines democracy, and I thought that it is incumbent upon the Attorney General to guide the President on the next course of action. Would you clarify to us and even lay, where possible, that opinion? Because this is not just advice. You said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you, colleagues in the public gallery this afternoon. We have students from Hatumbanja Child and Youth Development Center, Namaingo South County, Namaingo District. They are represented in Parliament by Honorable Wanyama Michael Dori and Honorable Makoa Margaret. They've come to observe proceedings of this House. Please join me in welcoming them. The Honorable Attorney General. Narrate the Attorney General, please. Answer some questions.
Thank you very much, Right Honorable Speaker.
I can pick another set, okay?
Thank you very much, Right Honorable Speaker. First of all, the court-martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medad Segona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Segona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. Was appealed against is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
Point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he's the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General, therefore, in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally, Right Honorable Speaker.
Procedure, Honorable Seshkova. Procedure.
Thank you very much, Right Honorable Speaker and members. Right Honorable Speaker, as a law student and a practitioner, the basic principle we are taught and we learn and we practice is that judgments of court, particularly the Supreme Court, are judgments in rem. They are not in personam. Meaning that all must abide not only the Attorney General, but the constitutional order in the country must listen and adhere. So, number two, the Land Attorney General, Right Honorable Speaker, did his best when he made arguments before the Supreme Court. He did his best. That is the best he could offer. Now for this House to demand and to expect a better alternative from him, I think would be too much. That is the best he could offer. He stayed the Constitutional Court order. He ran to the Supreme Court, prepared himself, robbed himself, got all his entourage with wheels and cattle. He proceeded to the Supreme Court. Unfortunately, he couldn't do better than he did in the Constitutional Court.
What is the
To that regard, Right Honourable Speaker,
I need the procedure matter.
yes, for this House to expect a procedural guidance from the Land Attorney General, when he had failed to convince the 7 justices of the Supreme Court, Mr. Speaker, sir, would be a big disservice, not only to this country, but to Parliament. And lastly, Mr. Speaker, I listened in very well. Once you talk about the Constitution, it is the paramount and the fundamental law we have. In his statement, I heard him say that the DPP, the Director of Public Prosecutions, should liaise with the General Court Martial to get files and process those files. Right, Honourable Speaker, for purposes of record and the Hansard of this House, Article 120 of the Constitution is the Director of Public Prosecutions. And Clause 6 states, in the exercise of the functions conferred on him or her by this article, the Director of Public Prosecutions shall not be subject to the direction or control of any person or authority. By the Land Attorney General telling the DPP to go and liaise with the General Court Martial is in total breach of this Constitution. And I would therefore like to say that his guidance, even now, is continuing to offend this Constitution. And therefore, I would pray that we give him leave so that he can rest, he can think about the events of this country, he can choose whether he wants to take the country to the constitutional path or he wants to take this country in the dark times, and without any delay, comply with the Constitution, with the Supreme Court orders, and release these persons detained, so that now the country can breathe a sigh of relief. Without that, whatever explanation is talking about, he's wasting the time of this House and is continuing to agonize the constitutional order of this country. And I pray that anymore, Mr. Speaker, sir.
Thank you. Now, just wait, Attorney General.
Thank you.
Just wait. Honourable, now, to begin with, I think we had started well, appreciating each other, both sides, in terms of the swift action that the Attorney General had taken. He told you immediately how he moved. Even on Sunday he was working, even yesterday he was working. So I think that was in the right direction. Now, where we are disagreeing is the content of what maybe he has written and what he has not written. And when I was listening on the issue of the DPP, and I would want it to be very clear, I heard you using the word I advise. I heard it several times, I advised. So meaning if the DPP still has a discretion of taking the advice or not taking it. So that's what I was hearing. I think, honorable colleagues, also when we say the Attorney General has guided the House wrong or what, we are not making any resolution on this matter. I asked the Attorney General to give us an update. This is a matter which has been settled by court. We cannot reopen it here. We just needed an update on how far he has reached in as far as implementing the court order is concerned, because honorable colleagues were raising this issue. We don't expect any other any other decision here that is going to override the decision of the Supreme Court. Attorney General, allow me to pick Honorable Okror, Bosco, and Honorable Fox-Odoi. Now I need to balance sides. Me first. You rushed to give information. You are fearing burning Honorable Okror.
I want to sincerely thank you, Right Honourable Speaker. I think I want to make a humble contribution to this discussion. Right Honourable Speaker, the judgment of court was pronounced. I think the most unfortunate thing that some of us are doing is thinking that we can read this judgment off from the original text. We have excerpts of judgments which people are reading and not understanding the exact judgment. Yes, you can say the pronouncement of court that the judgments of this nature are in rem. It is true. But even for you to find somebody in contempt, one of the executing officers, it ought to have been brought to the attention of that person. We have the judgment which has been delivered by court. But what can only be executed is an extract of a decree or an order, which is the responsibility of the lawyers who are participating in the case. So, Right Honorable Speaker, we can say they are self-executing judgments. That is right. But when you read the orders of this judgment, and I want to particularly look at one of the orders, it says that all charges, this is the judgment of Winyidolo, all charges, page 194, all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. The word immediate is there. It's immediately cease and be transferred. So when you are reading the text, the paragraph, the sentence, it has a continuing. So if you say, this is a matter of interpretation, and where there is a dispute as per the interpretation, it is not for Attorney General, it's for the court to settle that component. That what do you mean? Because court did not say release. If we are reading it to the dot, the court did not say release. Say immediately cease and transfer. Now, the process of transfer is a process. It is a process. So I think we need to understand it from that context. So we cannot castigate Attorney General for giving his view and all the processes that are being undertaken. But I think let's do our work. This is the real text. I beg to submit.
Thank you, Honorable Fox-Odoi.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker.
Order, Honorable colleagues.
Right Honorable Speaker, I will take you back in time. Take you back in time to a language that is now considered dead. This language used to be the language of instruction to lawyers. It is otherwise known as Latin. In Latin, we would summarize our discussion this afternoon in one sentence. Corte suprema alla cuta cosa finito. And I will translate that. The Supreme Court has spoken, all matters are settled. There's no matter left for discussion. There's absolutely nothing left for discussion. There's absolutely nothing left for resolution. There's nothing left for amendment. Even here, I understood the position of the Speaker to be a request to the learned Attorney General to render an account of the implementation of the court order. And I sat here attentively and I listened to the learned Attorney General render an account of the steps they have taken to implement the court order in an orderly manner. Because we do not expect them to implement the court order in a manner that will cause chaos. They will never be able to amend a single order from the Supreme Court. So, and he's only pleading for time. He's asking you for time to implement the court order. My land brother, Okoro, has already told you, even where the court said there must be cessation of prosecution immediately.
Point of order. Honorable Minister.
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, the Honourable Fox Odoi is the chair of the Human Rights Committee. He is supposed to help protect the rights of Ugandans. He knows that people who are now in prison are detained illegally and their rights are being infringed upon. Is he in order to say that what the Attorney General is doing is okay and people can be in prison and wait because he's doing it orderly? Is he in order?
Now, honorable colleagues, how will I be determining points of order on opinions? Because these are opinions. This is Honorable Fox Odoi's opinion. This is how he has understood it. Now, where will I bias myself? Say, for you, you're out of order. Your opinion is out of order. It becomes difficult for me. That's Honorable.
Thank you very much, Right Honorable Speaker, for your very wise counsel and ruling. Right Honorable Speaker, the Attorney General is in a very unenviable position. And at this very critical moment, I can only state that I have absolute faith in his knowledge of the law and his commitment to actions bona fides. So as a House, Right Honorable Speaker, I think it would be improper for us to impute malified intentions on the part of the Attorney General. I beg to submit.
Thank you. I had allowed Honorable Samuel as we were beginning.
Mr. Speaker, I want to thank you very much. The Attorney General has said the court martial cannot sit because of this judgment. For the court martial, they are not waiting for a decree. There are also no discussion with anyone else, but they immediately stopped functioning, and I want to thank him. For release of prisoners, including Dr. Wesige, who is in Ruzira now illegally, because there is no detention warrant. There, the DPP is realizing I have written to Supreme Court. Why didn't you render the same advice to the court martial that continue working as I liaise with the Supreme Court? Why do you think for them they needed to stop functioning immediately, but the others can continue disobeying? I am sympathetic to him. Maybe the same reason that court said military people cannot purport to be dispensing justice. Because the people were asking the Attorney General to advise, they have already expressed themselves. The CDF said Wesige can only get out of prison in a coffin. Really, what sort of advice can you give a person who thinks like that? Even if you are a professor of law, times 3. The CDF, one of the supervisors of the General Court Martial, has said Dr. Wesige can only get out of prison in a coffin. He had even arranged to kill him. He had even identified a tree in Guru. And that's why I sympathize with you. Sometimes, sometimes these jobs, sometimes these jobs, I think we may need one time the late Professor Chido Makuya was asked to offer advice to the president, and he said in law, you may or may give no advice. That's how he used to talk. In this case, I choose to give no advice. That's what he told the president. One of the reasons he was eventually sacked. Really, what advice do you give to a person who has made the statements that the CDF has made? And then the president who went to Luwero to fight, killing people because he wanted the power. Yes, in Luwero they were not hunting, they were killing. He even speaks about it, how he was robbing guns from barracks, from Kabamba to Masindi to Hoima. He writes up. Trouble is that you support him, but you don't read his book. Because if you did, all this information is there. He went to Luwero to kill, he killed, robbed the banks, including one in Kabale. And then he said he was fighting point number 1 of NRM is democracy. And he says judges don't rule. So who rules Uganda? The president and his son. That what they say is sacrosanct. Even the Attorney General, you are wasting your time. So when the Attorney General tells me, understand, whether you can render an advice to 2 military men who have already Mr. Speaker, the Constitution does not allow Parliament to take any decision whose effect will alter a judgment of court. In advising these military people who are not listening, the Attorney General said he was talking about an amendment. Can he tell us? And I listened to Honorable Fox Odoi very carefully, and I want to thank him. He said there's nothing to amend. But the Attorney General says they have advised him to amend. So what are you advising them to amend, sir? Thank you very much, Mr. Speaker.
Honorable Taylor John.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the technical issues about the judgment have been raised ably. What I need to add, Right Honorable Speaker, is the component of human rights. In the whole world, when it comes to matters that affect human rights, there is always a deviation from deeper technicalities, because the feeling is that people's rights are being violated. And from the wording of the judgment, any continuation of detention of the prisoners infringes their rights. What the Attorney General has put, which we should put much emphasis on, is how should we do it systematically so that order is maintained in the country. It would also be ugly to wake up in the morning and then people say we have stormed the Luzira prison to pick our people. So what I want to implore the Attorney General is to rightly advise the powers that be to have an expeditious handling of the implementation of the non-debatable orders that were made in the judgment, considering in mind that we still have a long list of individuals who are now falling in the category of people whose rights have been violated. And at this point, we also need to appreciate the position of the Attorney General, where he is the legal advisor to government. And his role is advisory. So I see us crucifying a messenger who has delivered a message.
Thank you.
Thank you.
Attorney General.
Thank you very much, Right Honorable Speaker. I think I just want to clarify on one issue that probably Lop raised. The decision, the issue of the position of the inmates now, all the inmates who are under the trial in the General Court Martial, all their matters are now under the jurisdiction of the courts of judicature.
Just wait, Attorney General.
Yes.
Kindly,
Yes.
Honorable colleague, take your seat. Attorney General, continue.
Yes. So what I'm saying is that the court said seize these matters and transfer them to us. That means that the court, the Supreme Court, handed the jurisdiction over any matter that relates to any of those people to the courts of judicature. Now, Honorable Segona, we can continue the debate. I have rendered advice. I have told you that the government has decided to comply with the court orders, and we are going to comply with the court orders as have been given by the Supreme Court. I thank you.
Thank you. Thank you for that update. Attorney General, please, I implore both sides to keep in touch with each other. Matters of national importance. Honorable Numbers, matters of national importance. Honorable Numbers, please.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I'm so grateful that you have allowed me to raise the matter of national importance.
2 minutes.
But I also want to let you know that all of us had thought that we would get an opportunity to contribute to the debate that was before us. But now that you have ruled that we proceed, Mr. Speaker, I want to remind this House, as a way of raising a matter of national importance, about the plight of travelers on Kampala-Jinja Road. Right Honorable Speaker, what is happening on that highway can no longer be classified as traffic jam, but a crisis in its own style. Right Honorable Speaker, the point of concern as I raise this matter now is the risk we are running as a country of having trucks filled with thousands of liters of fuel stuck in traffic jam for hours in a congested road, on a congested road, Mr. Speaker. Mr. Speaker, some of us don't want to be prophets of doom, but it would be very bad if we don't discuss this. That if it is not for just for the grace of the Lord who protects us Ugandans, any slight mistake, Right Honorable Speaker, and we will lose thousands of people and property on that road. In case of just a little fire, Right Honorable Speaker, or something near to that, Mr. Speaker, would sit here if some of us are not victims and count the losses. I know it is not easy to construct a road, but I think that there are technical things we can do to mitigate the problem, Mr. Speaker. For example, I remember some years back when I was young, trailers carrying goods from the would move at a particular time.
On our numbers, on matters of national importance, we have a time limit. So I said 2 minutes, we are now in 3. Just let's go on prayers.
Right Honorable Speaker, I want to pray that the Minister of Works and Transport comes up with interim provisions to mitigate the crisis.
No, please, honorable numbers, conclude your.
To mitigate the crisis on the Kampala-Jinja highway, I so pray.
Thank you, honorable. That's a very, very critical matter. All of us who pass there. So I think this is, I don't see the Minister for Works here, but right honorable Prime Minister, you want to respond, please?
Thank you. Thank you, Right Honorable Speaker. And I want to thank Honorable Namboze for bringing up such a question which is touching everybody. Right, Honorable Speaker, I just want to inform this House and of course the country that Ministry of Works is fast tracking the Kampala-Jinja Express Highway. The moment they get the money, it is being fast tracked. Secondly, Right Honorable Speaker, the drivers on that road, especially those ones who are using the big trucks, those are the ones carrying fuel and so on, they have been advised to use Kampala-Jinja Mukono road so that they avoid the traffic around that corner.
Madam Prime Minister, if I may advise, do you think it would be prudent, because your response should be based on her prayers, where she has asked for interim mitigation measures, okay? So can I, if I requested the Minister for Works to come and respond to this issue with clear interim mitigation measures, do you think it would be more helpful?
Right Honorable, that is right. I agree with you. But I thought for now, I thought I was giving information that can be used as we wait for the Minister of Works to come in. Because they had put a signpost to divert drivers who are using that highway to use Mukono, Kampala-Jinja, because those are big ones. Then the short ones, between Kampala and Mukono, can I finish? Between Kampala and Mukono, Right Honorable, there is railway transport that has been improvised now, so that those people can be using the railway. I thank you.
Thank you. Honorable Masaba Karim. Honorable, no, we've agreed the minister come on Tuesday next week with a statement that shows interim mitigation measures, and then we shall debate that. Okay. Honorable Sarah Najuma.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I raise on the matter of national importance about the road from Butalangu to Ngoma and from Ngoma to Chinyogoga. Right Honorable Speaker, there is a section from Chirangas to Ngoma which is becoming impassable. Even there are sections on Ngoma-Chinyogoga Road. Right Honorable Speaker, I contacted the Minister of Works. He sent us machines, but the machines are grounded up to now. And the engineers on ground are telling us to wait for some time, that we should wait up to April. Honorable Speaker, those are the only two roads from Ngoma to Butalangu and from Ngoma to Chinyogoga that lead to these other constituencies. Nakaseke North, those are the only two roads that connect Nakaseke North to Nakaseke Central and to Nakaseke South, and they are the only two roads that connect that constituency to Kampala. Right Honorable Speaker, April is very far, we cannot wait. And the engineers are complaining that they just lack only spare parts. Right Honorable Speaker, I request the Minister of Works to intervene so that the machines are back on the road. Thank you so much, Right Honorable Speaker.
Let the Minister respond on Thursday during Prime Minister's time. All right, thank you. Because Honorable Pio Samuel.
Thank you, Right Honorable Speaker. I rise on a matter of national importance on the delay in crop insurance payment for farmers under the Uganda Agriculture Insurance Scheme. Right Honorable Speaker, the government has been implementing the Uganda Agriculture Insurance Scheme, which is a public-private partnership between Ministry of Finance, which represents government, and the Private Insurance Association. Under this scheme, government subsidizes a percentage of the premium, and the farmers also pay a part of it. In 2022, more than 2,000 farmers in Kole district enrolled for this scheme and paid their premiums. They suffered crop failures, they were assessed, and they were due to be given awards. However, Right Honorable Speaker, it's now 2 years down the road and their awards have not been given. The reason that is being given is that government has not honored its part of paying the subsidies for those premiums itself. My prayer, therefore, is that one, the Minister of Finance gives us an update on the Uganda Agriculture Insurance Scheme, because we are now moving into the next rainy season. Secondly, I also want the Minister of Finance to tell us why government has not yet honored paying the premiums or the subsidies for the Uganda Agriculture Insurance Scheme so as to enable the farmers to be paid their awards. Thank you.
Can I also guide this is answered on Thursday? So that means of finance and agriculture can have time to meet over it. Was a motion?
Mr. Speaker, I move this motion and I want to thank you. Under Rule 59, 59B, 1B. And the motion, Mr. Speaker, is a motion of adjournment to discuss an urgent matter of public importance. So, Speaker, and I want to thank you. You were generous in allowing us to make comments the way we did about the Supreme Court judgment. But because of the importance of this judgment, I am moving this motion, Mr. Speaker, to persuade you to adjourn the subject matter under consideration and to allow us at least an hour to discuss this matter. Why? The defeat in court was not a defeat just of the Attorney General. In fact, when Parliament was making this law, the Honorable Chiwano Kachiriowa was not even the Attorney General. So this judgment also touches on how Parliament conducts business here. How you are advised, because the way the Chief Justice described setting up of the court martial, he said it's like asking him to go to Mulago to begin operating patients. That's what Parliament did, and any MP worth the name must take this as a very serious matter. That what we did, what Parliament did in setting up the General Court Martial was like telling a lawyer to go to Mulago to operate patients. And second, Mr. Speaker, the constitutional order in the country, this judgment touches on the constitutional order. That you have a military that has taken over management of society. The CDF is issuing one tweet after another. We are now asking Attorney General to advise him. So the motion, Mr. Speaker, of adjournment is to allow us to present these matters to the satisfaction of the public. The public now is very happy with the judiciary. It is time for the public to also be very happy with the Parliament, especially because it's this Parliament that established that General Court Martial. I am lucky I was not in that Parliament. Otherwise, the words of the Chief Justice. So that's the motion, Mr. Speaker, that I am moving to adjourn consideration of the matters on the floor now to discuss a matter of urgent public importance, and that's the judgment of the Supreme Court.
Thank you. Thank you, Honorable Semuju. No, wait, I guide before. I need to guide, okay? That's why I'm here. Now, this matter goes beyond Rule 59. It goes to Rule 64. 64.2. A member who desires to move a motion of this nature in writing should, if I may read it, a member desiring to move the motion under sub-rule 1, because it's a special motions, that's adjournment of adjournment motion, definite matter of urgent public importance. A member desiring to move the adjournment motion under sub-rule 1 shall, save in exceptional circumstances, given out to the satisfaction of the Speaker, would submit to the Speaker the terms in writing of the matter which he or she desires to be discussed at least 2 hours before the commencement of the day's sitting. Because you would have seen that is not provided for on the order paper. Number 2, under 64 sub-rule 4D, which is the right move, a motion under this rule is subject to the following conditions. The motion must not revive debate on a matter which has already been discussed in the same session under this rule. I gave this matter 45 minutes. We discussed it for 45 minutes. It's a matter that a member considered to be very important, so he should have gone to the Speaker 2 hours before I enter here, at least midday or 11, and say I have an urgent matter, which I don't see on the order paper. In my opinion, I will be moving that we adjourn debate on some items to consider this matter. Therefore, I find it effective and I cannot even put a question on it. Or guidance is not provided for anywhere in our rules. Yeah. Thank you. Our next item. Procedure Buvuma.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, last week on Tuesday, I raised a matter of national importance concerning a boat that capsized due to negligence of the UPD Fisheries Protection Unit. And one of my prayers was for this House to table the fisheries and aquaculture regulations, Right Honourable Speaker. And you requested government to commit themselves as of when these regulations will be tabled, and the third Deputy Prime Minister, Right Honourable Rukia Nakadama, committed herself that the regulations will be tabled within 1 week. So, Right Honourable Speaker, my procedural matter is, wouldn't it be procedural right for us to know whether the Right Honourable Rukia Nakadama has carried along with her the regulations to be tabled for this House, because the fisheries and the fisheries community, we are in need of those regulations.
Please, Honourable, a week has not ended. She told you a week has not ended, please. Stop putting on pressure. Honourable Mapenduzi, you had an issue.
Right Honourable Speaker, I rise under Rule 2182 of the Rules of Procedure of Parliament. Right Honourable Speaker, on the 19th of December, the Public Service Pension Fund Bill 2024 was referred to the Committee on Public Service and Local Government. And the committee was given a period of 45 days within which it should scrutinize and report back to this House. Right Honourable Speaker, you are aware that on the same day, Parliament went on recess. And when we returned, we were given a strict time frame within which we were supposed to consider the budget framework paper. And the committee had to accomplish that task. Right Honourable Speaker, considering that the 45 days has gone and we have just a few days, and it would be procedurally correct, Right Honourable Speaker, if you will find fit that the committee be granted permission of and you extend a period by about 3 weeks for the committee to adequately scrutinize and report back to this Parliament. Thank you, Right Honourable Speaker.
Thank you. Honourable colleagues, 3 weeks is okay? Okay. 3 weeks, let's give you, because we took 3 weeks away from you when you were handling the BFP. Okay. Next item.
Item number 3 on the order paper.
I have a point of procedure from Honourable Watkins.
Thank you very much, Mr. Speaker. Having been a friend and a very close friend to you before we even join this great institution. Mr. Speaker, sir, I'm duty bound to submit to constitutional authority. And Mr. Speaker, sir, this submission is in no way trying to challenge your decision. Mr. Speaker, sir, everybody in these chambers picked up a constitution and a Bible. I'm a Bible believer. I'm a Catholic. And a Quran. And then the Constitution. And Mr. Speaker, sir, we swore, or we took a constitutional oath. One, Mr. Speaker, to defend. Two, to preserve. And three, to protect the Constitution. Mr. Speaker, sir, we are drawing closer to a breakdown of a constitutional order. And the constitutional oath that I and yourself and everybody in the chambers took does not give us adequate room to see what is going on, continue on. Mr. Speaker, my procedural issue. Our Constitution is very, very clear. Article 92. And Mr. Speaker, sir, the Attorney General is aware that even when he's advising government, including this House, we are guided and directed by historic precedents. Mr. Speaker, sir, I want to draw the attention of everybody in the chambers to two precedents, which are his.
No, Watkins, I don't have that much time. Please.
Let me wrap up, Mr. Speaker.
Just tell us your point of procedure.
Yeah, this is about the Constitution.
No. Honorable Watkins, please. You are on point of procedure, okay?
This is the procedure matter,
so if
Mr.
you're on
Speaker.
procedure, okay? It's procedure. Please, procedure, point of procedure.
Mr. Speaker, sir, Semogeri and others versus the Attorney General, 2004. Malik Mabirizi versus the Attorney General, 2021. Crystal clear, Mr. Speaker, sir. We're not going to allow a total constitutional breakdown happening on our watch. I'm going to partner with my honorable colleague, Honorable Semuju. That is either that matter considered tomorrow or no matter. So my procedural issue, Mr. Speaker, sir, is having taken the oath, the constitutional oath, would we, Mr. Speaker, sir, be proceeding correctly while we see the executive undermining the very oath, because the ruling of the Supreme Court is non-negotiable? What I don't want, Mr. Speaker, is I don't want your leadership in this House to be co-opted in illegality and also criminality as it relates to offending Article 92 of our Constitution, which is crystal clear. Thank you, Mr. Speaker, sir.
Thank you. Now, I'm very happy I see Honorable Atkins wishes me well, wishes this House to have powers, you know, which would also be able maybe to use. But Honorable Atkins, my brother, here, we don't have powers of enforcement of court orders outside those directed at our institution. We can only comment. We can only comment, and that's why around all this much time, and I ask, we can only put the Attorney General and government task to update us. But when it comes court orders, we cannot come here and we give orders. We can't. These are matters of court, settled, okay? Attorney General and the team government, they know what they are supposed to do. Now, in case they don't do what they are supposed to do, okay, the other parties who are aggrieved can go to court for contempt. And I think one of the colleagues, I don't know who raised it, said, Mr. Byabashija, if we go to court to start proceedings against it, was Honorable Sechkuba, I think, for contempt. Honorable Nwagawa, yes, for contempt of court. So here, on such a matters, Parliament was not party. We can only comment. And even with our comments, we cannot start taking sides because court already made a decision. So, colleagues, I request you, I beseech your indulgence, that let us know where our powers stop and we remain playing within the boundaries of our powers as an institution. Next item.
Item number 3 on the order paper. Bill's first reading.
Wait, clerk. Remember, don't have Aisha.
Thank you. Thank you so much, Right Honourable Speaker. Right Honourable Speaker, there is a matter on agriculture insurance that is being referred to a minister to bring a response next Thursday. And close to a year back, I raised a question again on insurance, and the Attorney General asked for time to get information, and he has never gotten back to us. Would it be procedure right that on the same Thursday, he responds to a question that I asked here, where banks charge double insurance over top-up loans?
Honorable Attorney General.
Right Honourable Speaker, I do not recall undertaking to report back about double insurance of banks, because that's really way outside my realm of, I wouldn't have undertaken that. I think, but if you want me to go and research on it, I can do it, but definitely.
No, it's Minister of Finance.
It's Minister of Finance,
yeah,
maybe. I don't know anything about insurance and their double charges.
Just let me make it very easy for you, Honorable Aisha. I put it in writing, okay? Submit it, I'll ensure the Minister of Finance.
Right, Honourable Speaker, it's a question I've asked twice. That will be the third time. The last time I asked that question, it was addressed to the Prime Minister. The Prime Minister addressed the matter to the Attorney General. The Attorney General said, let me go consult and I come back.
Can I request, raise the matter now, okay? The way you wanted it, and I refer it to the right minister.
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, when people go to get loans from banks, especially when they're getting top-up, okay, ordinarily banks charge for insurance on every loan. When you go to get a top-up loan, again, insurance is charged. But when they are charging that insurance, they charge for the whole loan. Let me give an example. If you are left with a balance of a loan of 40 million shillings and you want to top up 100 and they're only going to give 60 million, they charge insurance on the whole amount of loan, which is double charging, because the portion that is you are not taking would be paid for already. So it is cheating people, charging them twice over money that is not taken. So my question was, is it fair, and why isn't government doing regulations that will guide banks not to charge people twice over top-up loans? Thank you.
Thank you, Minister for Finance. That's as a regulator.
Right Honourable Speaker and colleagues, if I have understood Honourable Aisha well, this is the matter between commercial banks and their clients.
They're asking a regulator. As a regulator.
We don't, Mr. Speaker, we don't negotiate on behalf of the clients. Take the loan or don't take. If the loan is bad, leave it.
Senior banker, you wanted to say something? Honorable Mara? Honorable Msasizi, you usually give us answers. Today I don't know who has disturbed you. You rarely give such answers. Honorable Mara?
Thank you very much, Right Honourable Speaker. The practice is always that every loan that we get from the bank, whether personal loans or vehicle loans or home loans, normally carries some component of insurance charges. And so it will run down for a period of time as agreed by the client. But if you have exhausted, let me say you borrowed a 2-year loan and you're finished 1 year and you want a top-up, normally that top-up will come with an insurance charge again. And it is a relationship, it's an arrangement, it's a product arrangements between you and the bank. Bank of Uganda or the Ministry of Finance has nothing to do with it. Now, if there is any disagreement, because what Bank of Uganda does is to make sure by regulation, all banks must display all their charges in the public so that the people can see, they can educate them. But if you choose to take a particular product, it would have been believed that you've taken it from a point of knowledge. So you shouldn't, they should explain thoroughly to you about the products, benefits, and the charges that come with it. So I don't think it's something that the Ministry of Finance would get involved in, or even the regulator.
Now, honorable colleagues, I don't have much time. You can see we are coming 4 p.m. Okay? Okay, Senior Counsel.
I want to thank you, Right Honorable Speaker. I think today, like you, I'm disappointed by the Honorable Henry Musasizi. I think the matter raised by the Honorable Member is of interest to the Ministry of Finance as regulator. One, we have Insurance Regulatory Authority in this country, which is established by law. Number two, banking practice is also regulated by law and supervised by Bank of Uganda. It raises 2 issues, one of law and one of consumer protection. If I were in his shoes, not likely, I would commit to carrying out investigations and then report. That's number one. I would also commit to bringing regulations that regulate that practice. One of the reasons why the economy continues to lag behind is because consumers are not protected. The credit facilities in this country remain very expensive, and these are areas which the Ministry of Finance needs to look into. When he shakes his head in this agreement and this belief, I get worried that he's not about to protect Ugandans, and he's not even bothered, even when he doesn't know. I would implore him to know, first to seek to know, then come and give us an informed answer.
Thank you. Now, honorable colleagues, when the consumers run it to us, to say, ask the regulator, we have this issue, I think we should listen to them. You know, because these are people who don't know our issues of technicalities. You can't just throw it at them, our issues of technicalities. Government Minister for Trade is not here, but I think Attorney General should be having information on how far we've reached with the consumer protection law, which government was working on. Maybe this would be helping us. They would be running to that either commission or committee or whatever it is. Do we have any update on the consumer protection law which government had promised? Okay. Attorney General will check and update her. So, Honorable Musasizi, take keen interest in the matter, and in 2 weeks report back to the House. Thank you. Honorable colleagues, in the public gallery this afternoon, we have a delegation of traders from Mbare City, Mbare District. They are represented by Honorable Masaba Karim and Honorable Koni Garwango. They've come to observe proceedings of this House. Please join me in welcoming them. Stand up for recognition. Thank you. Now I called Honorable Masaba earlier on to present his matter. Was nowhere to be seen. But for me to lobby more votes for him in the constituency, I'm going to, yes, I'm going to give him a chance to speak so that his people can see him speaking on the floor. Raise your matter.
Thank you very much, Right Honorable Speaker, and I think they have heard. Unfortunately, you called my name, but I'd gone to facilitate them to be allowed in because they told me it's a big delegation and they needed clearance from the DPC to allow them in. That's why I'd gone, and apologies for that. Right Honorable Speaker, the traders who have come are a group of a larger group. They're representatives of a larger group of some of the traders from Mbale City who were affected by some fires recently, a few days ago. I think some of you saw what happened on media. Many of the shops, over 20 shops, got burnt and they lost properties worth millions or billions of shillings, and many of them are currently devastated by what happened. And they actually traveled to Kampala. They sent a delegation to come to Kampala to meet the Prime Minister, but unfortunately she was held up, and I opted to come and raise this matter such that it can be picked up by the Office of the Prime Minister to see how best our traders can be helped, because they have lost properties and many of them are having loans and financial hardships. So that is why I'm raising this matter. The Office of the Prime Minister, there are two prayers. One is for an investigation to be done quickly such that they can know the cause of this, what exactly happened and led to these fires that led to the damage of their properties and loss of properties. Fortunately, we did not have any person who passed on because of the fires, because they happened at night and all their shops were closed. And the last prayer is for the government to run to their aid and see how best they can be helped, how they can facilitate them, because many of them have lost properties and do not know where to begin from. Thank you very much.
Honorable Konigar Wango, do you want to add on something?
Yes, right. Thank you. Thank you so much, Right Honorable Speaker. Right Honorable Speaker, allow me welcome my people from Mbale. You're most welcome. Kwa simire mwanyala kweza. Right Honorable Speaker, I'm sorry I've used that language, which is not. I'm sorry I've used that, but I wanted to show my joy for my people.
No, but what does it mean? What if you're saying they grab me from out?
I've said they are most welcome. Right Honorable Speaker, as Honorable Karim has stated, our businessmen and women have had very hard times after losing all that they had. Given the financial status right now and what is happening in the country, people are really struggling. And if people have struggled and have gotten little, and many of them operate on bank loans, and if you have got a bank loan and everything has gone, it makes them so desperate that many of them have even gotten sicknesses that they have never had because of the pressure that came out of the fires. Right Honorable Speaker, many times government has come up to help people who have had such tragedies. It's my prayer that something is done to see that they are real, they are rehabilitated. I want to thank you, Right Honorable Speaker.
Thank you, Minister for Disaster Preparedness.
Right Honorable Speaker, I want to confirm that we are aware about the incidents that occurred, and the team is doing an investigation to provide us with a report. And secondly, Right Honorable Speaker, I will collaborate with the members of Parliament, and we hold a meeting where the Right Honorable Prime Minister will be present so that we can see how we give them help. I can't be specific now because it involves compensation that needs investigation, and thereafter we'll be able to communicate back to them. Thank you.
Thank you. Next item.
Item number 3 on the order paper, Bill's first reading. 3.1, the Income Tax Amendment Bill 2025.
Honourable Minister for Finance.
Right Honourable Speaker, I beg to move a motion that the bill entitled the Income Tax Amendment Bill 2025, Bill number 2, be read for the first time.
Thank you.
Mr. Speaker, I also wish to lay the certificate of financial implications accompanying the bill. I beg to.
Thank you. The bill stands referred to the Committee on Finance, Planning and Economic Development and to be processed within 45 days, depending, but on Chair Finance, these usually are very, very critical, and it's very, very small. These are very, very, very critical clauses that we need to sort out quickly. Honourable Minister, how urgent do you need this bill? Because it's a small bill. I just need to look at the urgency.
Mr. Speaker, this is a one-clause bill, and I would wish the House to consider it at an earliest opportunity. But in any case, if we get it in 2 weeks, we shall be grateful.
Thank you. Maximum 2 weeks, committee.
The Income Tax Amendment Bill 2025. Item 3.2, the Excise Duty Amendment Bill 2025.
Honourable Minister.
Right Honourable Speaker, I beg to move that the bill entitled the Excise Duty Amendment Bill 2025 be read for the first time. Mr. Speaker, I have accompanied the bill with the certificate of financial implications.
Thank you, Honourable Minister. The bill stands referred to the Committee on Finance, process in line with Rule 129, but also 2 weeks' time.
The Excise Duty Amendment Bill 2025. Item 3.3, the Energy Efficiency and Conservation Bill 2024.
Honourable Minister for Energy.
Right Honourable Speaker, I beg to move that the bill entitled Energy Efficiency and Conservation Bill 2025 be read for the first time.
Is it accompanied by the relevant documents?
Right Honourable Speaker, I wish to beg to lay the Certificate of Financial Implications for the Energy Efficiency and Conservation Bill 2025.
Thank you, Honourable Minister. The bill stands referred to the Committee on Natural Resources to be processed in line with the Rule 129 of our Rules of Procedure. Next item.
The Energy Efficiency and Conservation Bill 2024.
Procedure, Honourable Matthias.
Madam Speaker, it's a small matter, but this being a bill, the record ought to read clear. The clerk calling the bill, the Energy Efficiency Bill and Conservation Bill 2024, the minister refers to a bill of 2025. May we know on record what we are dealing with, that the record is very clear?
Honourable Minister.
Right Honourable Speaker, the bill is labelled 2024.
Thank you. Let the record capture that. Thank you so much, Honourable Honourable Matthias Mpuga. Next item.
Item 4 on the order paper, statement by Minister on prolonged pre-trial detention.
Attorney General.
Thank you, Right Honourable Speaker. Right Honourable Speaker, honourable colleagues, I regret to report that we are unable to make this statement today. When the matter came up last week, the Minister of Justice made an effort to meet with the Judiciary, with the Chief Justice and the team. They were busy last week with the with preparation of the judgment. This came on Tuesday. They were not able to meet him. And this week they are handling the judges' conference, which started today, which should end on Friday. So the Honorable Minister has requested that he be allowed time to meet with the Chief Justice and then be able to report back.
Attorney General, what I thought was, because prisons updates the DPP and all the relevant authorities, I'm told they update them every 6 months or every month. The prisoners, they have their status and all that, okay? What would require meetings on this when you have records? Because maybe the chairman, Committee on Human Rights, can expound on it. I don't know the meetings, what the meetings are about, because the records are clear. Someone has been in prison for 16 years, someone 28 years. So Chairman, Committee on Human Rights.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I think you have explained it all. Only to add that we supplied to the Deputy Attorney General a comprehensive list of all remand prisoners who have been incarcerated for periods ranging from a couple of months to 28 years. And the list we supplied to DAG includes the locations at which they are being incarcerated, when they were arrested, what crimes they were charged with, and the periods they have stayed in incarceration. So I believe they have sufficient material to work with.
Yeah, because I don't know whether the judges are going to pronounce themselves the word B.
That's the point, Right Honorable Speaker. Having the list in the Attorney General's chambers does not give you the mandate to act on them, because these people are in the custody of the court. So the complaint raised here is to be taken to the court and say, there are these people. Even if we have them, the only person who can make a decision about that matter is the court that remanded them. I think that's why the minister would like to meet with the leadership of the Judicial. Allow us time, Right Honorable. I think the issue there is that you're seeking for their release, and therefore you have to go to the court to take that action. Ideally, you would have gone to the different courts to do that, but by going to the Chief Justice administratively, you can deal with all those in one place as the head of the judiciary. I think that's what the minister is trying to achieve.
So how much time do you think you need, Attorney General?
The minister has requested that you allow him to come back to this house next week after he has met with the Chief Justice.
Thank you. Next, Honorable item 7. No, item 5, Honorable. I'm also going to get liaise with the minister on this. This is a very, very critical matter. I just not leaving it lying low. Yes, item 5, honorable colleagues, I had a meeting with the chair budget committee today, and I found there was a delay in communicating my decision to the committee. So the committee was not ready. We agreed. They are meeting this afternoon and tomorrow to finalize, and then tomorrow afternoon we shall handle this rationalization issue. So let's do item number 6.
Item number 6 on the order paper, motion for adoption of the report of the Committee on Legal and Parliamentary Affairs on the ongoing update of the National Voters Register.
Chair.
Thank you, Mr. Speaker. Mr. Speaker, I have a 20-page document. The main copy is here, attached with the minutes. Report of the Sectoral Committee on Legal and Parliamentary Affairs on the ongoing general update of the National Voters Register. Mr. Speaker, I beg your indulgence that I read this document page by page.
I beg your indulgence, Mr. Speaker, that I read the document page by page, because at the end of the document, all the matters that have been raised will have been resolved, I think. On January 20th, 2025, the Honorable Deputy Attorney General presented the statement on...
Just let me guide you, Honorable. Try to be as detailed as possible, but 20 pages are too many for you to read word for word. But try to be
Thank you.
The
Thank you, Mr. Speaker. On the 20th January 2025, the Honorable Deputy Attorney General presented the statement on the ongoing voter verification exercise. During debate, a number of issues arose that required further interrogation. The Right Honorable Speaker accordingly directed the Committee on Legal and Parliamentary Affairs to interact with the relevant government agencies to seek clarification on the matters. Methodology: in the course of the work, the committee interacted with the Electoral Commission, National Identification and Registration Authority, NIRA, and the Uganda Bureau of Statistics. And we reviewed the following documents: the Constitution of the Republic of Uganda, Electoral Commission Act Cap 176, Registration of Persons Act Cap 332, and court rulings and Registration of Persons Act Cap 332. Now, the first matter is compiling of a voters register. This is a general matter that we need you to take note of, honorable members. Article 61, Clause 1, Paragraph B of the Constitution of the Republic of Uganda imposes a duty on the Electoral Commission to organize, conduct, and supervise elections and referenda in accordance with the Constitution. In performance of this function, Article 61, 2 directs the EC to hold presidential, general, parliamentary, and local government council elections within the first 30 days of the last 122 days before the expiration of the term of the president, parliament, or local government councils. One of the key activities that the EC must undertake prior to holding any general election is to conduct a general update of the register in each parish, ward, in line with Article 61, Clause 1, Paragraph E of the Constitution, and Sections 18 and 20 of the Electoral Commission Act. On Monday 20th of January, the Electoral Commission commenced the exercise. The provisions require the EC to compile, maintain, and update on a continuing basis a national voters register, which shall include the names of all persons entitled to vote in any national or local government election. Maintain as part of the voters register a voters roll for each constituency. And C, maintain as part of the voters roll for each constituency a voters roll for each polling station within the constituency as prescribed by law. Before compiling the voters register, the EC is required to register persons who qualify for voting in accordance with Article 59 of the Constitution and Section 20 of the Elections Commissions Act, and include them on the National Voters Register. Article 59 of the Constitution guarantees the right of every citizen of Uganda of 18 years and above to vote. The same article imposes a duty on the state to take all necessary steps to ensure that all citizens qualified to vote register and exercise their right to vote. Section 20 of the Election Commissions Act provides for the registration of voters and requires that a person is eligible for registration as a voter if that person is a citizen of Uganda and is 18 years and above. In proving a person's citizenship status, Section 69 of the Registration of Persons Act directs that the person must possess a national identity card or a national identification number issued by NIRA. In generating the voters register, Section 65(2) of the Registration of Persons Act, the EC is at discretion to compile, maintain, and update on a continuing basis a national voters register and use the information in the existing national voters register as well as the information contained in the registration of persons held by NIRA. After compiling a voters register, the EC is required to, in Section 24 and 25 of the Election Commission, has to display for inspection the voters register, a voters roll for each constituency, and a voters roll for each polling station within the constituency. The current voter register and verification exercise is in furtherance of the powers of the EC as outlined above. And the exercise is aimed to 1, enable eligible Ugandan citizens of 18 years and above who are not yet registered as voters to be registered as voters. The second aim of the current exercise is to enable registered voters who wish to transfer to new voting locations to apply for such transfer. The third issue is to enable registered voters to check and confirm that their particulars are correct and appear on the voters register at the polling locations that they indicated during registration. And number 4 is to enable students who are registered by NIRA and have since attained the age of 18 years to present their particulars, that is, the national identification number, for updating and assignment of a polling station within their parish of residence or origin. Consideration of the issues raised by members on the voter registration exercise. During the debate on the statement by the Deputy Attorney General, a number of issues were raised by members in relation to the conduct of the voters register update exercise by EC. The issues were extracted by the committee and referred to the agencies, EC, NIRA, and UBOS. Below is part of the committee, is the report of the committee on the issues raised, taking into account the responses received from EC, NIRA, and UBOS, and the legal obligations imposed on those agencies under the law. The first issue members raised is the registration of persons without national IDs, stroke NIN numbers by the Electoral Commission. A number of members questioned the current practice by the EC of registering first-time voters who do not possess national identity card numbers. The members urged that the Electoral Commission should not be registering first-time voters who do not possess NIN numbers, since such individuals have not been certified as citizens of Uganda. On its part, the EC informed the committee that it is currently registering persons to participate in elections, whether such persons possess NIN numbers or not. The EC explained that where a person appears and he has a national ID, the voter is registered by the EC for inclusion on a national voter. And if the person does not have a NIN number, then the person is registered by EC, and his or her particulars are collected and are transmitted to NIRA for registration and issuance of a NIN number. The committee has examined this matter and finds that the registration of voters is governed by the Constitution, the Electoral Commission Act, and the Registration of Persons Act. The committee is aware that Article 59 of the Constitution guarantees every citizen who is above 18 the right to vote. The same article imposes an obligation on every citizen of Uganda of 18 years and above the duty to register to vote in an election. Article 61(1)(e) of the Constitution imposes a duty on the EC to compile, maintain, revise, and update the voters' register. Section 20 of the Election Commission Act provides for the qualification of a voter in Uganda, and it requires that a person is qualified as a voter if that person is a citizen of Uganda and is 18 years of age or above. In ascertaining the citizenship of a voter, a person who alleges to be a citizen of Uganda must produce a NIN number issued by NIRA within the provisions of the Registration of Persons Act, Section 66(2) of the Registration of Persons Act. Just I'll go back a bit. Section 20 of the Election Commission provides for the qualification of a voter in Uganda. It requires that a person is qualified as a voter if the person is a citizen of Uganda and is 18 years of age and above. In ascertaining the citizenship of a voter, a person who alleges to be a citizen of Uganda must produce a national ID or a NIN issued by NIRA within the provisions of the Registration of Persons Act. Section 66(2) of the Registration of Persons Act requires a person to produce a NIN number or a national identification card, or alien's identification number, or alien's identification in identifying him or herself as a voter. The committee observes that the registration of a person as a voter is a two-step process, which is commenced by a person being registered by NIRA, issued with a national ID or a NIN, and therefore presenting himself or herself to the Electoral Commission for registration as a voter. The committee notes that the current practice adopted by EC of registering first-time voters who do not possess national IDs or NIN numbers is wrong, since by the time a person applies to the EC to be registered as a voter, he or she must have proved his or her citizenship status by registering with NIRA and being issued with a NIN or a national identity card, which certifies the person as a Ugandan. The committee therefore notes that it is wrong for the EC to register persons who are not possessed with national IDs or NINs because their mandate is to register citizens of Uganda for election, and a person without a NIN number has to first prove his or her citizenship before being registered as a voter. The mandate to register citizens of Uganda is the preserve of NIRA and cannot be ceded to any other person or authority. The committee therefore finds that the EC should only register persons who possess national identity cards or NIN numbers or student LIN numbers. Any person who does not have a national ID, NIN or student number should not be registered by the EC and should instead be directed to apply to NIRA to register and obtain a NIN number, ID or a student's number before they are registered by EC. Recommendation. The committee recommends therefore that during the update of voters registered, the EC should only register persons who are above 18 years and above and possess national IDs, NIN numbers or LIN numbers. Second recommendation, since NIRA and EC are carrying out complementary work, NIRA should consider undertaking registration of persons exercises during the period the EC is undertaking voter verification, so that persons who are not possessed with national IDs or NIN numbers can be registered by NIRA during the same exercise, and the records of such persons be shared automatically with the EC as provided in Section 66(2) of the Registration of Persons Act. The second issue, honorable members, was the adequacy of registration kits, stock registration of new voters at the sub-county level. A number of members raised issues about the registration of new voters at the sub-county instead of parish or ward as required under Section 20 of the Electoral Commission Act. The members urged that the registration of persons at the sub-county rather than at the parish ward has discouraged first-time voters from participating in electoral processes, since they have to walk long distances from their villages to the sub-county in order to get registered. Members also argued that their constituents have incurred a lot of costs associated with transportation and wastage of a lot of time on commuting to and from their villages and to the sub-county. The Electoral Commission confirmed to the committee that it had indeed supplied registration kits at the sub-county level rather than at the parish level or ward. However, the EC clarified that the kits are supposed to rotate at parish levels on different days during the exercise. According to the EC, the total number of kits deployed for this exercise is 2,703 biometric enrollment kits, instead of the required 5,000 kits. The distribution of the kits was made based on the sub-counties, except for Kampala and Wakiso and Mukono, which have been allocated additional kits per parish or ward. The EC confirmed that it had received 35,000 out of 36,000 tablets from Uganda Bureau of Statistics, and the remaining tablets were undergoing verification before issuance to EC. According to the EC, the kits obtained from UBOS are not suitable for this exercise, since they lack some of the features needed to carry out this work. The committee was informed that the 36,000 kits obtained from UBOS will be used for purposes of biometric voter verification during polling day. The committee observed that the practice of registering voters at the sub-county in some areas of the country instead of the parish or ward contravenes Section 20 of the Electoral Commission Act. The committee notes that this practice, born out of expedience due to the few number of kits that were made available to EC. The committee is aware that whereas the EC had requested for 5,000 biometric enrollment kits, only 2,703 biometric enrollment kits were made available. In order for the EC to comply with its statutory duties, it made the practical decision of distributing the available kits based on sub-counties in order to ensure that the exercise is carried out within the prescribed time. The committee notes that currently Uganda has 2,211 sub-counties, municipal divisions and town boards, 10,690 parishes or wards, 70,000 villages, stock cells, 11 cities, 146 districts, 302 counties, 31 municipalities, and 34,000 polling stations. If the kits for registration were to be stationed at every parish or ward as required under Section 20 of the Electoral Commission Act, the EC would require 10,690 kits, a number that is currently out of their reach. The Commission finds that the kits available to EC were insufficient, making it difficult for the EC to have full-time kits at every parish or ward, and therefore the committee also finds that the insufficient numbers of kits deployed for voter verification has affected the ability of the EC to carry out the voter verification exercise smoothly and with little disruption to the normal lives of the people of Uganda. Recommendations. In light of the above, the committee recommends that the EC should consider extending the deadline for the voter verification exercise in light of the challenges faced in the process. The government should prioritize procurement of election kits and other ICT equipment needed by EC, and the EC should, in compliance with Section 20 of the Electoral Commission Act, ensure that voter verification exercise is carried out at the parish or ward. The other issue, honorable members, was the functionality of the kits used for voter verification and update. Members were concerned that the functionality of the registration kits have argued that the registration kits are obsolete and constantly break down, thereby delaying the registration process. The members were also concerned that of the slow pace of the verification of individuals, reasoning that since the registration kits are old, they can only work on a limited number of people, and in most areas not exceeding 50 per day, thereby occasioning delays in the registration process, leading to frustration of the would-be voters. The EC confirmed that they have received reports of breakdowns in the kits used for registration of voters and update. EC attributed the breakdown of the kits to the old age of the kits, on account that the kits being used for the exercise were first procured for the 2014-2015 mass enrollment and registration under the National Security Information System Project, the predecessor of NIRA. NIRA informed the committee that the kits used by EC were procured by NIRA in 2014 and are 11 years old at the moment. According to NIRA, the kits are at the end of life and end of support, and their performance is suboptimal because of degradation over time. Precisely, they are obsolete. The committee was informed that as a mitigation measure, the EC has deployed ICT teams to deal with the problems experienced during the voter verification exercise. On its part, NIRA informed the committee that it was in the process of acquiring new 5,500 biometric enrollment kits, data center, equipment, and a new national security information system at a cost of 666.85 billion. According to NIRA, government has so far released a total of 300 billion, leaving a balance of 366 billion. However, due to delays in releasing of funds, only a few of the kits procured by NIRA have been delivered, and the rest, together with the new system, have not been supplied. NIRA was, however, hopeful that it would procure, contract, install, configure, deploy, train, and have a working system before the end of the year. So in other words, these ones cannot be available for the process and currently undergoing. The committee observes that the failure to replace the old and obsolete kits used for voter verification and registration is an indicator of bad planning on the part of government, which has not only allowed the use of obsolete kits but also failed to release all the money acquired to procure new kits for both EC and NIRA. This has therefore crippled the operations of the EC during the voter verification exercise. The committee further observes that the failure by government to provide the EC with its
Honorable,
own...
you want to read word for word. We are going to sleep here.
Oh.
The report will be captured on the Hansard, all of it. Just go on observations.
Yeah.
Okay.
Thank
Not
you.
a silent issue,
Thank you,
not
Mr.
recommendation.
Speaker. On this particular issue, our recommendation is that the EC should consider periodically and continuously updating the voter register with information obtained from NIRA in accordance with the Section 65 of the Registration of Persons Act. The other observation is the government should urgently release all funds needed to procure, contract, install, configure, deploy, train, and have the new 5,500 kits kits operation in order to ensure that the 2026 general elections can run smoothly on the new national security information system. The other recommendation is the government should consider enabling the Electoral Commission to directly procure all its essential equipments by themselves and not relying on other government agencies, as the case has been on the voter verification exercise. The other issue, Mr. Speaker, and I'm now going to adopt the method you have advised, is the requirement for a recommendation from the Gombolola Internal Security Officer, the Parish Internal Security Officer, and the District Internal Security Officers in the voter verification exercise. Honorable members, the issue of, if you peruse, you realize that the reason why they have been using these people is because of the mistake they used it to bring in new voters who didn't have any numbers. And so, these GSOs and PSOs were supposed to verify citizenship, which we have said was not their mandate. That's the mandate of NIRA. If it was done that way, PSO, DSO, they would never appear anywhere. But they have combined the system of new voters who don't have any numbers with the exercise of verification. So to that end, the committee recommends that the EC should only register persons who possess national IDs or NIN as required by Section 66(2) of the Registration of Persons Act. In case the EC wishes to verify citizenship status of a person, the EC should contact NIRA, since it is the only competent body in Uganda that can attest the citizenship of a person. And the EC should immediately discontinue the involvement of DSOs, PSOs, and GISOs in the verification exercise, since their involvement in the process is legally and administratively redundant. The other issue was exclusion of school-going children from the voter update exercise. Honorable colleagues, when you read, you'll understand that after this exercise, pupils, students who have attained 18 years of age from March onwards will not be on the register. Why? Because the Electoral Commission says their register should be ready by June for them to be able to start conducting elections. And the first elections are actually in June of the youth, the PWDs, and the other special interest groups. So they are time-bound. Any child who will attain 18 years after March will not be able to vote. So we have made a recommendation that the committee recommends that NIRA should ensure that all learners in Uganda are registered and issued with LIN numbers. And once they are 18 years of age, their particulars are transmitted to EC for inclusion in the voter register in accordance with Section 65 of the National Registration of Persons Act. But this will only be for this period of the exercise. Any youth who will attain 18 years of age after this exercise, they will not be able to be put on the voters. The other issue was lack of electricity in some sub-counties. Members complain that some sub-counties don't have power, and the kits sometimes are redundant because they are not charged. So the Electoral Commission, we have made recommendations. Government should endeavor to extend electricity to all parts of Uganda for the future. EC should ensure, EC should procure kits with the EC should procure kits with longer battery usage, in addition to providing power storage and backup systems in areas with unreliable or no electricity supply. And the other recommendation is EC should immediately provide standby generators to sub-counties that don't have power to ensure that this exercise moves well. The other issue is unavailability of voter registers and the slow pace of voter verification. That was at the beginning. And I'll read this one because it is there is something good there. Members raised concerns on the delays in the commencement of the voter verification exercise in some constituencies due to, among others, delays in dispatching the voter register to relevant polling stations. The members averred that the delay affected the smooth verification of exercise and led to voter frustration and apathy. The EC admitted that in the beginning, the exercise in some parts of the country did not start smoothly as expected, but now the exercise is moving very well. EC instituted various measures to ensure that the exercise can be completed smoothly, including deploying supervisors in every district of Uganda to ensure that matters that raise are well handled. However, the EC also indicated that it is monitoring the situation on ground in real time, and if need be, EC will extend the time for the exercise. That one, we got an assurance from them that they are monitoring, they are going to be reporting to us, and I have a report I received today that should there be need to extend, they will indeed extend the time. The recommendation is that the committee recommends that the EC should plan appropriately to ensure that verification and other voting materials are delivered on time. The committee recommends that the EC should consider extending the deadline for the verification exercise due to the disruptions experienced at the beginning. Then, irregular removal of voters from the roll. Colleagues, the EC explained that it is not within their mandate to remove voters, and that the process for removal of voters from a roll is elaborate under Section 26(3) of the Electoral Commissions Act, and that any voter who has been removed erroneously has an opportunity in this period to be reinstated back, but also during the display of the voters' register, which is upcoming, I think, within 3 or 4 weeks from now. During that period, if you go and realize that you are not on the voters' register, there's going to be a tribunal, you raise a complaint, and you can be reinstated back. The committee recommends that the EC introduces mechanisms that prevent the removal of voters contrary to the provisions of the law in order to ensure credible, accurate, and transparent voter register. Any person whose particulars are missing from the voter register after the current voter verification period can have the particulars included in the voter register during the period of voter display as required in Section 25 of the Electoral Commission Act. The issue of charging money from voters by PSOs, GISOs, and some LCs, the Electoral Commission acknowledged that indeed there are some complaints that have come up and said they are making follow-up to ensure that such is not, does not take place and is illegal. Recommendations, the committee recommends that the EC informs the public about any fees payable, if any. That the EC makes complaint reporting and handling processes simpler and more accessible to the people, and engages investigative agencies of government to investigate and prosecute persons who impose any fees from the voters. And that the EC makes the verification of voters simpler and removes unnecessary procedures and the processes that may be used to perpetuate corruption. Then, colleagues, the issue of use of 2014 census results in demarcation of electoral areas. We had here that in some areas where we are supposed to have, where there used to be 3 or 4 councillors, now there is either 1 or 2 councillors. This was caused by the usage of the 2014 data in demarcation of electoral areas. The Electoral Commission explained that because of the timeness, the time they are time bound, they had to demarcate areas, and yet WUBOS is not ready with their statistics, with the data of the 2024 population census. And the reason WUBOS gave us was that there are conflicts in many areas of the country, and they gave us those areas here. Apa, there is a dispute in Apa between Amur and Adjournment. There is a dispute in Pararo or Kora area. There is a dispute in Ombechi, Kochi, Legura, Mogi area. The dispute is between Yumbe and Obongi districts. There is a dispute in Nyamisingira area, and therefore, WUBOS says they are waiting to sort these disputes out with the Minister of Local Government and the local areas, the local leadership, and then thereafter they can be able to release the 2024 data, which goes up to the sub-counties, villages, and parishes. So, as it is now, we have resolved that, we have recommended that the Electoral Commission reviews the demarcation of electoral areas in all the parishes in Uganda to ensure that using the population quota prescribed in Section 120 of the Local Government Act will not result in a number of councillors being less than 10 in a local area as required in Section 124, because there is a mitigation measure under Section 120 of the Local Government Act. Where councillors are less than 10 in a local government, the Electoral Commission has a mitigation measure under that act to ensure that they step up they cut down on the numbers to ensure that at least every local government has 10 councillors. WUBOS urgently releases the 2024 census results.
Conclude,
that the Minister of Local Government...
Chair, conclude.
I'm concluding, Mr. Speaker. The Minister of Local Government should urgently resolve all the boundary and other disputes affecting local governments as explained. Low level of voter education, as you have realized, colleagues, and we talked about here, voter education has been lacking. It has been minimal, not as required. So we have recommended that in accordance with Article 61G of the Constitution, the EC should formulate comprehensive and detailed educational programs for the education of the voters on the 2026 general elections. EC should expedite the process of procuring entities to carry out voter education. EC should ensure that voter education exercises are undertaken before end of the election processes begin. Mr. Speaker, I'm concluding. The committee has examined the issues raised by the members and found that some of the issues affecting the voter registration exercise are likely to have a negative impact on the credibility, accuracy, and transparency of the voter register. The legal regime pertaining to the conduct of elections requires that voters must be registered in order to be eligible to participate in an election. The voter registration is intended to ensure that everyone entitled to vote can do so, to prevent ineligible persons from voting and to guard against multiple voting by the same individual. The accuracy of the voter register is a key element in ensuring that all qualified constituents can enjoy their right to vote. Since the credibility of the entire electoral system depends on the accuracy of the voter register, government needs to ensure that resources are made available to the EC to undertake this delicate process in time. Every government agency that has a bearing on the compiling, maintaining, and update of the National Voters Register should play their role to ensure the timely delivery of the Voters Register at the time of the election. The committee finds that the challenges identified by members during the voter verification exercise have in most cases arisen from outside of the Electoral Commission and from other government agencies, departments and agencies. In the instant case, the delay by the Minister of Finance, Planning and Economic Development in providing funds to NIRA to procure the new 5,500 biometric enrollment kits, data center and equipment, and the new NCI system has affected the carrying out of the voter verification process in a timely and efficient manner. Likewise, the delay in supplying valid up-to-date data from EC by UBOS has affected the demarcation of constituencies and other electoral areas. Therefore, there is need for government to operate in a coordinated manner, since a failure by one government agency or department or institution has a catastrophic effect on the operation of the EC in the execution of its mandate. Mr. Speaker, that's the end of the report, but two issues, and very briefly, Mr.
No, Chair, even before you got those two issues, just first leave the rest. Please take your seat. No, you have a report which members signed. So is it part of the report?
Mr. Speaker, I received the current update from the chairman of Electoral Commission as of yesterday.
No, Chair, your role was to read the report.
Oh.
If there is any update, the minister is around.
Thank you, much obliged, Mr.
Yeah, thank you. Now, thank you, Chair, you've done a wonderful job. But, honorable colleagues, I have been guiding the House on several occasions, but sometimes it's difficult. People say, no, we have, Now, Article 62 of the Constitution, independence of the Commission. Subject to the provisions of this Constitution, the Commission shall be independent and shall, in the performance of its functions, not be subject to the direction or control of any person or authority. The recommendations we are making here, we are telling the Electoral Commission, go adjust boundaries, extend the deadline, do what? It's in contravention of Article 62, Chair. And moreover, we are beneficiaries of the electoral process. We cannot be here defying the law which this House legislated upon. Rob, do you want to say anything about it? I have not yet opened debate on the report. I'm only bringing a matter of the law on where the limit of our powers stops.
Honorable Speaker, the legislature is the third arm of government, and the executive is accountable to this legislature. And that's why when we raised these matters, when I specifically raised this matter, is because ultimately the people of Uganda have recourse here in the legislature through their legislators. The report is saying EC should consider extending the period of the voter verification exercise. We are not sitting here and directing and saying, EC, you should extend this period by 30 days. If you don't, we are going to do A, B, C, D, E. That's not what we are doing. We are saying, EC, based on all these challenges, which they also admit, because they have also admitted to, number one, their kits are not adequate, because you find one kit where you're lucky per sub-county. Where you're unlucky, 3 sub-counties are using one kit. Some of these kits are defective. The voter education exercise has not been adequate because LC1 chairpersons who are part and parcel of this process, many of them are just getting to know now. So the Electoral Commission is conceding that there have been challenges, and that's why we are saying it should consider extending, because it is their duty. They are the ones that came up with this roadmap. They are the ones that can extend. So we are playing an advisory role for their good as well, because they come to Parliament saying, now give us money for this exercise, give us money for this other exercise.
Just Honorable John, I totally agree with. I just want you to take me on the matter of the law. I'm a presiding officer of the House. I want to preside over the House lawfully. Okay? So, issues of justification, what it's very, very simple. Can we interfere with? Yeah, it's here. Because when you go for one recommendation, for example, I have here recommendations where we are directing EC on what to do. I have the EC should review the demarcation of electoral areas. Okay? I have EC should EC should engage investigative agencies to investigate and prosecute who, yes, I brought it to you. Otherwise, I would have ruled. But I want us to be within our limits in as far as the law is concerned. Okay? Only
Maybe
that.
finally, Right Honourable Speaker, I actually agree with you because, previously I was raising the concern of the DPP not being directed. But you see, the Electoral Commission falls under a certain sectoral committee, even for accountability purposes. Vis-a-vis, how are they utilizing the resources given to them and accountability committees? Number two, are they executing their mandate within the law? So I think it is okay for Parliament to say, by the way, your mandate as the Electoral Commission is to follow this law. In demarcation and that kind of thing, please follow the law. I think that's within our powers as Parliament to call to order any entity in this country because it is our oversight role.
Thank you. Honourable Mpuga.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I must first of all state that I'm a member of the Committee on Legal and Parliamentary Affairs. Yeah. And therefore, in enumerating the issues before the House, we had in mind the limitations of our duty. And there's a reason why the EC appeared together with the UBOS and the NIRA. Synchronizing their role is part of accountability. And if you go by the command of Article 63, particularly 5, sub-article 5, on the roles of the Electoral Commission, barely 10 months the elections, and they have not done that role, and the abdicative, outlook of UBOS in releasing the census results, this Parliament is really doing its work in reminding them of that application and reminding them of the timelines within which they have to execute that mandate. Mr. Speaker, sir, I think we are moving well. The report the coaching of the language of the report could probably sound as though directing, but we are reminding these agencies of these critical obligation to the people and under the Constitution. So we are within our limits, I contend.
Thank you, Honourable Numbers.
Thank you, Right Honourable Speaker. Right Honourable Speaker, it is true that the Constitution provides for the independence of the Electoral Commission, but I think that is in relation to the fact that the Electoral Commission itself is also doing things in accordance to the Constitution. Because it is the same Constitution that provides for the powers of the people of Uganda through their elected leaders. And it is the same Constitution that provides Parliament and its oversight law, Right Honourable Speaker. As long as the Electoral Commission is not following the Constitution and the laws of Uganda, I think it is right and prudent for Parliament, on behalf of the people of Uganda, to call them to order. For example, Right Honourable Speaker, it is provided under the Constitution that the determination of electoral areas shall be done after a census, and then that was a census in Uganda in 2024, and the Electoral Commission is saying, no, we are using 2014 census results a decade ago, more than a decade ago, Right Honourable Speaker. And by doing that, they are differentializing the people and denying them leaders. In certain places, like in my council, for example, they left us with councillors who cannot be used to constitute a council and its organs, like forming up committees of the council, i.e. the executive committee and the other working committees of the council, Right Honourable Speaker. So, Right Honourable Speaker, We should not allow the Electoral Commission to hide behind their independence to violate the Constitution. We came here and we took an oath to defend the Constitution at all times, and by calling on the Electoral Commission to do what is right, Mr. Speaker, we are defending the Constitution and ensuring that the power of the people of Uganda prevails through their elected leaders. I beg to move.
I think, honorable colleagues, my issue is not on us calling on the Electoral Commission to do a right thing. You can do it through any forum. Is us making resolutions, okay, which we are saying go implement as the Electoral Commission. Since it's a matter of the law, we have the Attorney General here. I need your guidance on this.
I think, Right Honourable Speaker, I think what your guidance is quite right. The issue is not we cannot discuss the electoral process. The issue is that what instruction are we giving? For example, if you say the EC should immediately discontinue the involvement of DSOs, PSOs, etc., etc., you have now gone to another point. So you need to tell them that the identification, no, for example, when you say you cannot register people who don't have NINs, that's not correct. Because the law says that the Electoral Commission may use the register. It is only for identification. So you need, what I'm saying is that, and I think I agree with the Right Honourable Chair, or Speaker, that when we are going about this, if we are giving advisory recommendation, they can be given on matters of principle. The moment you start telling them how to conduct a particular function, we may cross the line. That's, I think, what the Honourable Speaker is saying. Thank you. Right Honourable Speaker, if I could guide, we could receive the report of the committee and have them look at the matter.
Yeah, thank you. Now, honorable colleagues, I want to give my ruling on this matter. Okay? I'm uncomfortable presiding over a house which is interfering with the powers of a body of which we as legislators said should be independent. If we wanted to interfere, we should have expressly stated it here. I just want to make that very clear. But I consulted a little bit, been talking to the Electoral Commission following up on these issues. Let us send this report to them as a gesture of goodwill and showing because the report has captured all the issues which members were looking at. Let us, because the moment we say we first adopt it, then Rule 220 will require them to come and report here within certain timelines. But let us take advantage of the goodwill that Parliament has shown the Electoral Commission. We send them this report, and we shall, at an appropriate time, Minister of Justice will update us. Okay? Yeah, will update us on this. Now, yes, Rob. I've made my ruling. Rule 87 guides you on how to challenge my ruling.
Honourable Speaker.
Just go to the rules, you can challenge my ruling. Yes.
Honourable Speaker, without revisiting your ruling, I'm just trying to see how we get a balancing act so that the concerns raised by the people of Uganda through the legislators are attended to. How do we get committal from government that they are going to attend to these issues, and for that matter by way of an update, because these issues are very critical, they are of concern out there. So I don't know, maybe let me wait to get your attention, sir. I wanted to see how you could guide, right, Honorable Speaker, how we get committal from government to address these concerns of the general public, because these are cross-cutting issues. Cross-cutting, by the way. This side, that's what our people are raising as concerns.
Can I have the attention of the Attorney General?
So how do we, Mr. Attorney General and government, get committal that these issues of concern are going to be addressed in a timely manner? Because that's what is hovering over us, really.
Attorney General?
Right Honorable Speaker, we can have the Minister of Justice come back here, say next week, to report on the actions that have been taken, having listened to what Parliament has to say, in form of reporting back on the process of...
we can say, Attorney General, we can say, the Minister updates the House, okay? And on the process. And in the update, he takes cognizance of these issues which had been raised here. Now, that even gives us the freedom to debate his statement. Okay, it makes it much easier for me to manage the debate on the floor. So, colleagues, next item. No, please. No, let me make it very clear on this issue. No procedure, okay? I'm done. Next item.
Item number 7 on the order paper. Motion for adoption of the report of the Committee on Tourism, Trade and Industry on the museums and monuments, in brackets, declaration of protected heritage resources and heritage resources of significant value to Uganda, regulations 2024.
So, Attorney General, the process ends on Monday. Can the Minister of Justice update us on Thursday? Okay? Yeah, let the Minister update us on Thursday.
Sure, Right Honorable Speaker.
Thank you. Just wait. No, wait a bit. Honorable colleagues, on this item, number 7, just, please, I'm on item number 7. By the way, it's not mandatory that I allow procedure. Colleagues, I just want to make it very clear. It's in my discretion that I can allow any point of interruption of debate in the House. So I request you, when I say procedure, sometimes I've been also pushed very far, okay? And I need to move, I'm stuck somewhere, okay? Honorable colleagues, on Thursday, 17th October 2024, the Honorable Minister of State for Tourism, Wildlife and Antiquities, Honorable Martin Bahinduka Mugara, tabled the museums and monuments, bracket declaration of protected heritage resources and heritage resources of significant value to Uganda, regulations, statutory instrument number 69 of 2024, which the House referred to the Committee on Tourism, Trade and Industry for scrutiny in accordance with Section 95 of the Museum and Monuments Act, Cap 149. Section 95 of the Museums and Monuments Act states that the Minister may, by statutory instrument, on the recommendation of the Department, make regulations for better carrying into effect the provisions of this Act. Without prejudice to subsection 1, the Minister shall, by statutory instrument, in consultation with the Minister responsible for mineral development and with the approval of Cabinet, declare protected heritage resources and heritage resources of significant value to Uganda. 3, a statutory instrument made under subsection 2 shall be laid before Parliament. 4, Parliament may, by resolution, revoke the statutory instrument laid under subsection 2, 3, or a particular provision of the statutory instrument within 30 days from the date on which the statutory instrument is laid. Honorable colleagues, the provision mandates the Minister, having consulted Cabinet, to declare protected heritage resources and heritage resources of significant value to Uganda by statutory instrument, and this statutory instrument was laid in Parliament. The section further requires that once the statutory instrument is laid, Parliament may by resolution revoke the statutory instrument or particular provision of that statutory instrument within 30 days from the date on which the statutory instrument is laid. Honourable members, I note that the Minister laid the statutory instrument in Parliament on 17th October 2024. And I further note that we have exceeded the 30 days within which Parliament was expected to have taken action of revocation of the statutory instrument or a particular provision of the instrument. Given the above, I therefore guide and rule that we are constrained by the limitation of 30 days time frame to consider the committee report, and therefore guide that the statutory instrument laid in Parliament on 17th October 2024 was approved by Parliament by virtue of lapse of time in accordance with Section 95 of the Museums and Monuments Act, Cap 149. That's very, very clear. Next item.
Item number 8 on the order paper. Motion for adoption of the report.
I think I shouldn't stop there. I should really apologize. I should apologize on this. Really, this was a big oversight, and I hope it doesn't happen again. And also, Rule 129 of our Rules of Procedure gives 45 days. I don't know when we were making the act. At least we should have complied with Rule 149. Be the committee followed Rule 129. But, Honourable Minister, since you interacted with the committee, I would propose to you that you receive this report in good faith, though now it's not a report of Parliament because it's not adopted, but you receive it in good faith. You look at it, then you can propose amendments. Okay? Can propose amendments in line what the committee had proposed. This would be good for your for the good relationship between you and the committee. You want to say something about that?
Much obliged, the Right Honourable Speaker. It's good that the committee had equally agreed with the statutory instrument with some recommendation, and I want to assure the House that we'll go ahead and implement the recommendation in the report by the committee. Thank you,
because this item is vacated. It's as if we allowed the minister to continue with their statement. Thank you. Next item. Oh, yes, procedure matter, Honourable Mpuga.
Thank you, Right Honourable Speaker. It's because I did not capture your eye when the matter was still alive, but related to a matter earlier vacated, but not trying to bring it back as a matter of debate. And you have been consistent in ensuring that Parliament takes its role. That thread of debate and guidance even carried through an earlier debate on the role of the Attorney General in the release of prisoners after the court ruling. And I think that is the way to go. Now that we have taken that route of sticking to our role, Right Honourable Speaker, and the Attorney General is in the House, 3 months ago, I tabled before your office a plethora of amendments to cause reforms of electoral matter. And that role to which we have a duty we have not played as a House, Right Honourable Speaker. One, may we be guided by the Attorney General whether he has any reforms of legislative nature is bringing that relate to elections. 2, when will mind see the order of the day on the order paper? Now that that's our role, and therefore we stick to that.
Thank you. As I look for an answer to give you, let us start with that one. He seems to be more ready.
Right Honourable Speaker, I have not received any instructions to draft any reforms from the Ministry of Justice, but I'll check.
So, Honourable Mpuga, just let me also go back. I could check with the clerk. I consult our technical team, and then I give guidance on the matter. Okay? Thank you. Yes, Honourable Sasaga.
Yeah, thank you, Right Honourable Speaker. Right Honourable Speaker, some time back in the 9th Parliament, I presided over a committee of Parliament, and that was Government Assurances Committee. And such a scenario also happened. That the time which has been allocated to the committee to process the work and present had expired. But the committee had done its work and finished processing the committee report. The challenge was the work could not get itself on the order paper until that time allocated indeed expired. For such a scenario where a committee has done and processed its work, but the work has not got itself earlier on the order paper, like for example, this committee report, under such circumstances, how should you proceed as Parliament? Thank you so much.
Thank you. Honorable, the law does not talk about when the committee finished work. The law talks about when the decision was made by this House. So I don't know when the committee submitted the report. I need to go back and cross-check. But even if I do that, it's post-mortem. The law doesn't consider the committee report. The law considers a resolution of the House. And that's why I've said, honorable colleagues, that that was a fault on our side. It was a mistake on our side. And I'm praying that this doesn't happen again. When we have statutory deadlines, we should meet those statutory deadlines. So I'm going to go back with the clerk. We shall look through and we'll be on a clear guard that it doesn't happen again. Yeah. Yes, Margot.
Yeah, thank you, Right Honourable Speaker.
But I don't know
the clarification
from who, because no one on the floor, and on clarification, there should be someone on the floor.
Yeah, from the two.
No,
submission.
that doesn't. Honourable Babiku? Clarification, there must be...
the clarification I was making is even from your submission, right?
Yeah, but you're not sure who it is.
Yeah.
You started from the two, you are okay? Eh?
Right, Honourable. It's because
yeah.
He stated that such a scenario happened. And again, the question came back to you. The question I was posing, what happened to their report? Did it proceed so that there is a precedent to use, or it didn't proceed?
You see, honorable colleagues, I allowed, there is a law to use. Okay? If there is a law to use, why should I look for precedents to use? There is a law to use, and it's very clear. Okay? Now, I put this matter on the order paper so that it can be formally vacated. Otherwise, it was going to remain pending on the order paper. But what is very important is ensuring it doesn't happen again. Yes, Honorable Babiku.
Thank you so much, Right Honourable Speaker, for this opportunity. I really request that I understand something better from you based on your earlier ruling that on the issues of elections.
No, Honourable, that's closed. If you want to submit on it, you challenge my ruling, you follow Rule 87. Thank you. Yes, Honourable Rolla.
Thank you, Right Honourable Speaker. I just wanted to add on to what you said about these reports, and I take note that you have apologized and you have guided basing on the law. But Right Honourable Speaker, I wanted to say that these reports sometimes do not come within the confines of the law because they're not given space on the order paper. This almost happened to an ad hoc committee when we were investigating the National Council of Sports. And Right Honourable Speaker, it looks ugly. Sometimes it's suspicious. The members go out there, we do our job, we finish, and yet you, the presiding officers, have told us to do this job. You don't give us space on the order paper, and yet at the end of that day, we're going to be accused that, you see, they were bribed, something happened. So I want to implore that Right Honourable Speaker, as presiding officers who manage the order paper, this incident should not happen because it tarnishes the names of the members of that committee. I thank you.
I totally agree with you. I totally agree with you, Honor. Yeah. It's very unfortunate. You know, there are things which we shouldn't pretend. Okay, this was ours as presiding officers, and we failed on it, and we have to ensure it doesn't happen again. Working with our clerk, we should be ensuring this doesn't happen. Pachuto? I can pick on a white shirt. You look for the microphone.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, previously I asked a question to the Minister of Internal Affairs whether women that dress up in hijab would be allowed to register with their photographs taken with their hijab. And the Minister said yes, they would be allowed as long as they dressed in accordance with the ICOA standards. Right Honorable Speaker, ICOA standard is just the way I am dressed. I've even searched to look for pictorial evidence how ICOA standards are. But I regret to inform the ministers here in the House that Muslim women are again forced to remove their headscarf. They are told ears should be out. ICOA standards do not say ears should be out. The registration exercise is about to expire. Can the Attorney General be comment to this so that the Muslim women be given the right to practice their faith and yet be able to exercise their democratic role of voting their people, and also being able to possess identity cards in the way they want to look like? Because the minister had said they would be allowed. I don't know what is wrong. The taken people say that their machines are programmed in a way that ears should be displayed. But ICOA standards of dressing is just the way I am dressed. Can we be guided by the front bench on how Muslim women should be registered? Thank you.
Thank you. Now, as we come to that, without the presiding officers taking away their responsibility, which includes supervising the committee leaderships and the clerks, I have seen here the office of the clerk received the report on monuments on 31st of January 2025. Okay? So which was way beyond the 30 days. So also the committee, but we are going to go back. I just wanted to put it on record that we should have ensured ourselves that it comes before that time. So I will ask, I will talk to the clerk, that will also bring in the committee clerk to know why a committee clerk should allow this to happen, because they are technical people who should be knowing this deadline. Attorney General, you've heard Honorable Aisha Kabanda.
Thank you very much, Right Honorable Speaker. I have quickly flipped through the law and didn't tell us how a person should be when they are taking the picture. So I need to get some time to understand that. Obviously, I think there are certain things that must be done. I think the face must be clear. I don't know. I'm going to just read on it and understand, because understand how it needs to be done. I really don't have an answer right now.
Thank you. Honorable Attorney General, this is a concern of the Muslim community. You kind of take it up serious. I had allowed Honorable Pachuto.
Thank you, Right Honorable.
Maybe it can be one of the issues. Attorney General, Honorable Attorney General, can it, when they are updating us, they can touch on this issue on Thursday? Okay? Yeah. Thank you. Honorable
Thank you,
Pachuto.
Right Honorable. Right Honorable, I appreciate the fact that you have apologized and also guided. But Honorable, Right Honorable, I'm seeking further guidance. When a committee like the one of trade now has made a report and brought to Parliament, and it has been referred like it has been referred now, and we, the representatives of the people, that have felt that we would add value by making a contribution on the floor, because some of these monuments, for instance, are there in our districts. How would you guide us on how we can proceed now that we are not going to debate? How can we present the views of our people, the recommendations of our people, the desires of our people? Right Honorable, that's what I wanted to seek, because I'd really prepared myself to make a contribution on the committee's report, because I have several monuments in Pakwach districts, some developed, some not developed, some not even marketed at all. So, Right Honorable, I seek for your guidance. I thank you.
Thank you. Now, Honorable, unfortunately, the consequences of our mistake, we face them together. Okay? Honorable Jonathan Odur, you wanted to comment on the same?
Yeah, thank you. Mr. Speaker, this instrument is part of the laws that we make here, and they are not cast in the stone. If there are issues with the instrument, the minister can still, in my opinion, amend that instrument and come back here. So the best way forward in the circumstance would be for the members to reach out so that the minister can again commence a process of reviewing it. But coming back to the core issue of this delay, Mr. Speaker, sir, may I summarize it to one thing. Committees are not given money to do business at the right time. When you retreat back and you hold a meeting with the clerk and maybe the Minister of Finance, let committees of Parliament be provided money in a timely manner to conduct business. If you interrogate the reason for this delay, you'll find that the committee did not have money. And I think that is what we should address. Once money is available, this Parliament and the members of Parliament are really competent to dispose of these matters, even within a week or two, Mr. Speaker.
Thank you. That's well noted. Honorable Jonathan Odur, what you've said is really in line with how I had guided the minister. And the minister had committed. So let's go on with that commitment from the minister. Honorable Pachito, your issues will be served under that. No, next item.
Item number 8 on the order paper, motion for adoption of the report of the Committee on Tourism, Trade and Industry on persistent human-wildlife conflict in national parks and wildlife game reserves in Uganda.
Honorable Chair.
Thank you so much, Right Honorable Speaker. Honorable Speaker and colleagues, I wish to present the House the report on the Committee on Tourism, Trade and Industry on persistent human-wildlife conflict in national parks and wildlife game reserves in Uganda. Right Honorable Speaker, the Committee on Trade and Tourism was assigned to consider the matter with guidance to emphasize aspects related to government compensation to victims of human-wildlife conflict, specifically to establish whether victims of human-wildlife conflict were compensated and related matters. Right Honorable Speaker, the committee wishes to inform this House that whereas the matter raised by the Honorable Okello Geoffrey Charles was limited to havoc caused by elephants among some residents of Noya district, the committee considered other wild animals involved in incidents of human-wildlife across the country. Right Honorable Speaker and members, in accordance with the instruction of this House, the committee wishes to present its report on the matters. Right Honorable Speaker, briefly I'll go through the terms of reference because they will guide us in the report. Right Honorable Speaker, the committee was guided by the following terms of reference. 1, to establish the extent of damage, loss, or death suffered by victims of human-wildlife conflict, to establish whether government compensates victims or survivors of victims for losses suffered on accounts of human-wildlife conflict, to establish government adherence to the legal framework on the compensation of deaths, injury, loss, and damage to property arising from incidents of human-wildlife conflict, and to consider the matters that are incidental to human-wildlife conflict in areas adjacent to wildlife parks. Right Honorable Speaker, cause of time, I'll skip the methodology, but just to bring it to the attention of the House, that the committee, among the methodology, the committee extended invitation to members representing areas adjacent to national parks where incidences of human-wildlife conflicts have occurred, and members from the following districts interfaced with the committee. The districts are listed there. Right Honorable Speaker, because of time, I'll go straight to observations, findings, and recommendations of the committee with your guidance. Right Honorable Speaker, number 1 term of reference, extent of damage, loss, or death suffered by victims of human-wildlife conflict in areas adjacent to national parks and game reserves in Uganda. Right Honorable Speaker and members, in the course of considering the matter with the ministry responsible for wildlife and UWA, The committee established that some incidents of human-wildlife conflicts have resulted in injury, loss, and damage to property. The committee further established that livestock has been preyed upon by predators and destruction of crops by herbivores. A list of claims received by UWA is attached here too and marked as Appendix F, which I will lay. Right Honorable Speaker, the committee received testimonies from affected persons on incidences of human-wildlife conflict that have occurred in areas adjacent to national parks and wildlife game reserves in Uganda. For instance, Right Honorable Speaker, I'll just mention A, death of Amunyo, Longoli, and Angok Dennis. Right Honorable Speaker, these were killed by buffaloes. B, the death of Mr. Jacob Mujizi. Right Honorable Speaker, he was equally killed by a buffalo. It's from Barara. Right Honorable Speaker, C, we have baboon attacks on Sensa Mwesije. This one is from Rubirizi District. D, Right Honorable Speaker, displacement of families occasioned by human-wildlife conflicts. During the committee's visit to some hotspots in Noya District where incidents of human-wildlife conflict occur, the committee was informed that 7 families sought sanctuary at Gonyogo Community Primary School in Gonyogo Village, Lutuka Parish, after their homesteads were destroyed by elephants. The committee was informed by UWA that the Wildlife Conservation Committee had since gazetted. Right Honorable Speaker, the committee was informed by UWA that the Wildlife Compensation Committee had since gazetted of Uganda Wildlife Scheme 2022, convened 12 times and verified 583 claims and recommended the same to the Board of Trustees for approval. Right Honorable Speaker and colleagues, you can see the extract in Appendix H. Right Honorable Speaker, the committee was informed by UWA that factors such as increasing human-wildlife population, wildlife habitat loss, climate change, and wildlife fires have orchestrated human-wildlife conflict. The committee was further informed by UWA that despite clear boundary demarcations, human beings residing in areas adjacent to national parks have defied such demarcations and